Good morning. Does your company work with other competitors to create an agreement to not cold call each other's employees? If yes, then your company is potentially at risk for violating criminal and civil sections of the Competition Act. Being an HR professional in Canada, there are certain rules for hiring and compensation. We will take a look at the laws and risks of such practices. Section 45 of the Competition Act is the criminal section. If the purpose and effect of the agreement is to fix the price paid to employees for their services, it could be classified as price-fixing agreements under Section 45, and your company will be held liable. With the agreement made, each competitor is able to restrict the movement of employees and limit the salary they are able to potentially earn. In particular to the case with Google, Adobe, and Facebook, all three companies are agreeing that they will not cold call each other's employees. This limits the potential increase of the employees' salaries if they did potentially switch companies. You might be thinking, what are the penalties if found guilty? Remedies for committing a civil offense includes prohibiting a person from doing anything under the agreement. Penalties for committing a criminal offense includes fines up to $25 million, imprisonment for up to 14 years, or even both. To ensure your company is compliant with the law, companies should implement risk management techniques such as a corporate compliance program, which helps identify what you and your employees might be doing illegally. It also helps put processes in place to establish procedures, training, and monitoring. Being an HR professional, the culture of compliance is very important because it helps build our company's reputation in the marketplace. ICC Antitrust Compliance Toolkit can provide practical tools for small, medium, and large companies wishing to build and maintain a strong compliance program. The toolkit has practical tips and issues that companies should consider. Also, Compliance Outreach Program provides an open space for companies to discuss compliance issues in a practical way. Companies are able to share experiences and to learn about effective compliance practices through other companies. Let us tie everything together. Arranging agreements with competitors to lower competition can put your company in danger. Your company can be civilly liable. If proven guilty, will prohibit a person from doing anything under the agreement. If your company is criminally liable, your fine can be up to $25 million or 14 years imprisonment or even both. To prevent your company from being at risk, there are lots of risk management techniques your company can implement. For example, ensuring your company has a strong corporate compliance program helps your company identify illegal acts in your company. ICC Antitrust Compliance Toolkit helps companies of all sizes build a strong corporate compliance program. Also, Compliance Outreach Program provides an open space for companies around Canada to share their experiences and ideas.